Hello, and welcome to this week's live stream Coffee Talk with immigration attorney Brian D. Lerner. So, a lot of times people wonder what exactly adjustment of status means and how that might affect them and allow them to be able to obtain status in the U.S. Well, first of all, let me define what adjustment of status means. When someone is here either legally or illegally, and they don't have a green card, they're here either with their work permit, they're here unlawfully, they entered the country without inspection, they are here on an F1, H1B, temporary visa, whatever it is. The adjustment means that in some manner, which there's lots of different manners, they are allowed to adjust status to become a lawful permanent resident. Okay, that is what adjustment of status means. That is different than change of status, whereas change of status is dealing with when you have a non immigrant visa category, such as F1, and you change status to, for example, a work permit, such as H1B. So, normally, when you adjust status, you have to be here legally. Because if you're not here legally, then you will not qualify to adjust status and you'll have to leave and do consulate processing, and you may need to do waivers of inadmissibility, which you may or may not be eligible for. So the adjustment of status is done through either employment or family or some other means, such as through religious means, such as through being victim of criminal activity, battered spouse, through investment means. So there are, many different paths in which you can adjust status. One of the most popular, of course, is through marriage to a U.S. citizen. So that is where one of the exceptions comes in, where you can actually adjust status while being here illegally. So, what is the nature of this exception? Well, you have to actually have entered the country legally. Now, let's say you did it 20 or 30 years ago, whenever. And let's say you married last year and you're married to a US citizen. The exception is that if you entered the country lawfully and legally, that even if you're out of status right now and you're married to a US citizen, that you're considered what's called an immediate relative and you are eligible to adjust status to get the green card. Now, a lot of times, clients will tell me that they don't remember entering because they were so small, they were like a baby, and their mother or father brought them through in the car. The car was inspected and they were allowed through. Well, in that case, it's still possible to file an adjustment of status, but what has to happen is it has to be adjustment of status through declaration of legal entry, where the person trying to adjust makes a very detailed declaration of how they entered, when they entered, and of course, if they were a baby and or a child and too small to remember, then the person who would remember, who might have some knowledge of it, will be able to determine whether or not they did enter legally and then allow them to get the green card. So sometimes when people get married, they're only married to a lawful permanent resident, not a US citizen. And this exception that I've just spoken about does not apply if you are only a lawful permanent resident. You have to be a US citizen. Now, that does not prevent the case from going forward. In fact, all that has to happen is the lawful permanent resident has to apply to naturalize to become a US citizen. And then once the person's a US citizen, then the beneficiary can adjust status. There's also one more category of immediate relative that falls under this exception, and this is when there is a son or daughter who's a US citizen over 21 petitioning their parent. So let's say it's the same thing, but let's say that they came years and years ago with their parent and both are illegal, and somehow or another the son or daughter either was born here or not only was born here, but either married on their own and became a lawful permanent resident, and then eventually applied for naturalization themselves. And so, in that particular regard, as long as the parent entered legally, the son or daughter who's a US citizen is able to petition to get lawful permanent residence. So, no matter how you entered, assuming it was legal, whether it's through a B2 visitor visa, whether your visa was stamped on an ESTA, whether you had an H1B, however it was, as long as you can prove that legal entry and you are either married to a US citizen petitioning you or you are the parent of a US citizen who is over 21, you can file for this and you can obtain residency, assuming you're not inadmissible on some other ground. Okay, if you like the live feed, click like, subscribe, and more on the coming weeks. Thank you. Bye.